When a prospective DWI client comes in the door, they often are very upset. They have been through a process that they have never been through before, and they have a lot of questions about what is going to happen to them as their case progresses through the court system. The first thing I like to tell clients is I like to take them through the whole process, at least in summary fashion, so they have an idea about what to expect. And when there's a DWI prosecution in New Hampshire, most times there's both a criminal process through the court and a separate and parallel administrative process involving potential loss of license as well through the Department of Motor Vehicles Bureau of Safety. The criminal process is much like you've heard described in any TV show, movies, etc. The first component is someone would be they would have an arraignment, and a formal arraignment you would go in front of the judge, and you would either enter a plea of guilty or not guilty. Fortunately, in New Hampshire, most times if you hire counsel, that can be done by without actually having to appear in person. So we can file an appearance on your behalf, letting the court know that we're representing you, making the court know that we do not wish to have an arraignment, that we enter a plea of not guilty, and then the court will schedule a trial down the road. Most of the district courts in New Hampshire have a delay of between 6 and 8 weeks between the time of arraignment and the time of trial. During that time, we are in a process of gathering information. That information includes the police reports. The prosecutor's office is required to give us a copy of the police reports and everything that's in their file that they intend to use to try to prove you guilty. They are also required by the Constitution to give us anything in their file that might be exculpatory or helpful to your case. Usually that consists of the police report and any potential witness statements. At the trial, the state has the burden of proof, just like they would in any criminal case. And that burden of proof is proof beyond a reasonable doubt. They have to prove all of those. They have to prove all the elements of the offense against you beyond a reasonable doubt. And in a DWI, that typically includes they have to prove that you were driving, and that you were driving on a public way, which is typically a road, but it can also include a parking lot and certain other circumstances. And they have to prove that you were impaired by alcohol to any degree. Separately, if you are charged with a per se complaint of driving in excess of 0.08, or if it's an aggravated DWI in excess of 0.16, they would, instead of proving impairment to any degree, they would have to prove the BAC or breath alcohol content in excess of that numerical limit. But totally separate and apart from that is the administrative process. If you submitted to a chemical test with a result of 0.08 or higher, or if you refused the chemical test, you can be subject to an administrative suspension. And for a first offense, that's 180 days. For a second or subsequent offense, it's 2 years. And that process runs typically at a faster pace than the court process. If we, when you are arrested, you probably received a pink sheet of paper that, if you were licensed in New Hampshire, would be your temporary driving permit. That piece of paper also tells you that you have a suspension that goes into effect 30 days from the date of your arrest. And that suspension is automatic, which means unless we make some effort to, that suspension is automatic. So that goes into place without any further activity on our part, and will go in place unless we request the hearing, we request it in a timely manner, and we prevail at that hearing. And the administrative hearing is somewhat similar to what you expect in court, but it's a lot less formal. The standard of proof is much lower, whereas in the criminal case, the state has the burden of proof beyond a reasonable doubt. In the administrative hearing, the proof is preponderance of the evidence, which is a civil standard. The evidence that you would expect to hear in the administrative proceeding does overlap in many respects with the criminal case. Typically, you would have the officer who arrested you. He would testify. He would also be subject to cross-examination, so we could cross-examine him. It's recorded and it's under oath. So many times the biggest advantage of the administrative hearing is getting the officer's testimony locked in under oath and recorded, so then we can use that later on to your benefit at trial. The hearings examiner, who's the one who decides whether or not the state has sustained their burden of proof at the administrative hearing, is not a judge. Doesn't wear a robe. They typically are a lawyer, but they are not a judge. And the setting is much less formal. In a criminal case, the case will be heard in the courtroom in front of a judge with the prosecutor there. In the administrative hearing, we go to the Department of Safety, Bureau of Hearings, and we sit around a table. It's recorded with a small portable recorder, and the hearings examiner, again, who is a lawyer but not a judge, will decide the case. Other questions frequently asked by clients coming in the door for the DWI are, what are the consequences if they are found guilty? What's the worst thing that's going to happen to me? Well, I already mentioned for a administrative suspension, that's either a 180-day or a 2-year loss of license if you fail to prevail in that hearing. In the criminal case, for a DWI first offense, there is a minimum loss of license of 9 months. However, that can be reduced down to 90 days under certain circumstances. There are minimum fines. There are alcohol screenings and evaluations and potentially treatment that you would have to undergo and pay at your own expense. And there's an impaired driver education program, which is a 24-hour class that you also have to pay for out of pocket. And those things are very, very significant. However, there's also a lot that goes on beyond what the court or what the administrative process will do for you. It's a criminal conviction. If you are convicted of DWI, it's a Class B misdemeanor in New Hampshire, and that is a criminal conviction. And there are many collateral consequences for that. If you are convicted of DWI, you will not be able to get your license reinstated unless you file what's called an SR-22, which is insurance on your license as opposed to insurance on your motor vehicle. And that can cost several $1,000s per year, and you have to carry that for 3 years. There are also social stigma attached to a DWI conviction and other costs associated with that as well. So what can be done about it? How can I help you with that process? Well, a lot of things can be done about it. Just because you are charged with DWI does not mean that you will be convicted for DWI. There are many things that we can do. We at this office take pride in looking under every piece of paper, examining every document, every piece of the state's evidence that could possibly be used against you, and see where the flaws are, so we can use those to your advantage, both through litigation and through negotiation. Many DWI charges result in either findings of not guilty or negotiations down to lower and lesser included charges, and save the client the costs and expense and the shame associated with a DWI conviction.